Hello everyone and welcome. My name is Anne Harridge Truman, or Harry for short, and I'm Group Lettings Director here at Andrews Property Group. For those of you who don't know, we are a multidisciplinary property group covering lettings, sales, land and new homes and mortgages with 40 branches across the south of the UK. I'm also president of Arla Property Mark, so we have 18,000 letting and estate agency members across the UK, and we believe in upholding the highest possible standards in agency. So onto the presentation. So first of all, I'll be doing a short market update, and then I'll be handing over to Patrick Ansell. Patrick Ansell is a partner and head of property litigation at Taylor Rose Solicitors. Taylor Rose are a multidisciplined top 60 UK award-winning law firm with a market-leading property department covering all aspects of property law, including conveyancing, commercial property, all private client work and property litigation. Patrick will be covering the Renters' Rights Bill in depth, and if you have any questions as we go through, please pop them in the Q&A box, which will enable you to put your questions forward, and then other people can like them if it's a popular question that you would like answered. And we will pick out some of these questions and answer them towards the end of the webinar. Okay, so on to some market stats for you. So first of all, I thought I'd talk to you about rents and where rents are looking in the UK at the moment. So average UK monthly rents, private rents increased by 8.1% in the 12 months to February of this year to £1,326. This annual growth rate is down slightly from 8.7% in the 12 months to January, and it is below the record high that we saw of 9.1% in March 2024. So here's a quick graph for you to show the change in rents over the last 10 years. So the top bar is the top light blue bar is England, and then the darker bar below it, line below it, is the whole of the UK. We've then got Wales and Scotland and Northern Ireland on there as well. So the current rent is £99, so 8.1% higher than 12 months previously. So average rents have increased by nearly £100 in a year. For England specifically, the average rents now in England have increased to just under £1,400, sitting at 1,381. So as you can see, that dark blue line there has grown massively over the last 10 years, from somewhere around 900 to now nearly 1,400 in just the last 10 years. UK rents are expected to increase by 3 to 4% over 2025. So they believe we will see a slowing, but there will still be increases. So here's just some stats on private rents by English region. So not surprisingly, London was the English region with the highest rents inflation at 9.9% in the 12 months to February. This annual rise was lower than the 12 months to January and below the record high annual growth that London saw in the 12 months to November 2024. Rents annual inflation was lowest in Yorkshire and the Humber at 4.8% in the 12 months to Feb, and this annual rise was lower than the 12 months to January. So we're seeing that London are having the highest increases and Yorkshire and the Humber are having the lowest. Average rent was highest in London at £2,235, and lowest average rent was in the North East with £715 a month in February 2025. Moving on to house prices. So average UK house prices increased by 4.9% to £269,000 in the UK in the 12 months to January 2025. This annual growth rate is up from 4.6% in the 12 months to December. So if we look at the devolved nations on their own, so average house prices were 291 in England, but 210 in Wales and 187,000 in Scotland in the 12 months to January. When we look at demand, so there has been a modest 11% increase in the number of homes available for rent over the last year. So rental demand is down by almost a fifth, 17% compared to a year ago. So this graph is quite interesting when you look at the purple line is where we are now. The grey line is what a normal rental market was pre-pandemic. We've then got the pink and the black lines, which are showing post-pandemic demand. So the highest we saw there is in 2022 to 2024 in the summer. We saw record demand there of over 30 applicants per property. So we're currently looking at 12 applicants chasing each home for rent. So this is down 42% on the 2022 to 2024 levels, but still higher than pre-pandemic levels. So just some observations on our private rental market at the moment. So we are facing some major policy changes. This is why you're on this webinar today, to hear all about the Renters' Rights Bill. And this is likely to limit new investment and growth in the stock of rented homes over the next few years. This follows on from tax changes and higher mortgage rates for landlords. So this has meant that rental stock levels have remained static at around 5.5 million since 2016. As we know, the Renters' Rights Bill is likely to come into force later in 2025, and this is looking to reset the relationship between renters and landlords. In addition to renters' rights, we also have the government consulting on the need for private rented homes to have an energy rating of C before they can be let out from 2028. We believe that almost half, 45% of rented homes require private investment to get from a D to a C, and nearly 1 in 5 of private rented homes are currently E, F or G rated, which means we could be even more at risk of being lost from the rental market, eroding available supply even further. So that was my take on some market stats for the moment. I'm going to hand over now to Patrick, and he is going to take you through the Renters' Rights Bill in depth.
Thank you, Harry. I am just about to share my screen. So, Harry, if when I've done that, if you can confirm that we're on the right slide, I'd be very grateful.
Yes. We're on your first slide, Patrick.
We're on my first slide. Thank you very much. Well, that's that bit out of the way. Good evening, everyone, and thank you for joining. I am the partner in charge of property litigation at Taylor Rose. I've been at the firm for about 10 years. I won't say too much more because Harry's already touched upon the areas of work that we do. This evening, I'm going to be talking primarily about the Renters' Rights Bill, which is, as probably everyone will be aware, a very important bill that's currently going through Parliament. And I will also touch upon gas safety, because we find that it's still one of the areas where landlords make mistakes, generally inadvertently, and it causes them problems to obtain possession of rental properties. And that's going to be an issue that's going to likely continue after the Renters' Rights Bill becomes law, and it's worth having a catch up on. So moving on to my next slide, what is the Renters' Rights Bill? Well, the Renters' Rights Bill is the biggest change of the goalposts in terms of landlord and tenant law for over a generation. Since 1997, the default type of tenancy for the majority of private rentals has been the assured short-hold tenancy, which I'm sure a lot of you landlords will be familiar with. Assured short-hold tenancies came into existence in the late 80s, but they became the default, like I say, in 1997, following, I think, the Housing Act of 1996, if I'm correct. So before we move on to what the actual Renters' Rights Bill will be changing, let's have a recap on what we have at the moment with assured short-hold tenancies. So firstly, they will generally involve an initial fixed term. You don't have to have a fixed term. You can be immediately on a periodic tenancy with an AST. However, most people have an initial fixed term of a minimum of 6 months. Often it will be 12 months. The general rule is that the tenant can't bring them to an end before the end of that fixed term unless the landlord agrees. Otherwise, they may be contractually obliged for the rent for the remainder of that fixed term. The landlord can't bring the tenancy to an end during the fixed term unless they have grounds for possession, which I'll come on to shortly. The assured short-hold tenancy becomes periodic after the initial fixed term has ended. So after your initial, say, 6 months or 12-month fixed term, it will then become rolling and will essentially continue indefinitely until it's either renewed or either party is terminated. After the end of the fixed term, you as a landlord will be able to bring it to an end for any reason by serving a Section 21 notice, which often we will refer to as a no-fault notice. Now, you obviously need to make sure you can serve a valid Section 21 notice, but assuming you can then commence county court proceedings. In tandem with Section 21 notices, you've got Section 8 notices. They're notices which are essentially mean you're giving a reason for possession. Often that will be because of some kind of default by the tenant, and that type of notice can be served during the fixed term as well as afterwards. It runs as an alternative to Section 21 with ASTs. Some of the grounds that you have with Section 8 notices are mandatory, some are discretionary. Obviously, discretionary ones mean persuading the judge that you should get possession, but they don't have to give you it. The mandatory ones, if all of the relevant conditions are made out, then you get your possession order. And as things stand, and I'll come on to how it may change later, as things stand, the most common mandatory ground that we'll use for Ground 8, Section 8 notices is under Ground 8, and that's for serious rent arrears. And at the moment, that means that the tenant has at least 2 months worth of arrears when you serve that notice, and they need to maintain 2 months, minimum of 2 months arrears at the date that you issue the proceedings. And again, at a hearing, if all of those things can be proven, you get your possession order. So what is going to happen with the Renters' Rights Bill? Well, some of that will be in the dustbin. The dustbin I found on the stock images unfortunately had a number 23 rather than number 21, because that would have been a bit more apt with Section 21 being done away with. But you get the point. So let's summarise some of the key changes that you need to be aware of with the Renters' Rights Bill. I should say at this point that at the moment we're in the House of Lords. You may be able to hear the bells of St Paul's behind me, so apologies for that. At the moment, the bill is going through Parliament. It's currently in the House of Lords at the committee stage in the House of Lords. So we don't know the final version, but we think the majority of what's currently in there is going to be how it stays. So bear that in mind when I run through everything. I'll start off with a summary and then move on to things in a bit more detail. So firstly, as mentioned, Section 21 notices are going to be done away with. The no-fault eviction route won't be there anymore. We'll no longer have fixed-term tenancies. So essentially, a tenancy will be rolling from the beginning. There'll be a protected period, however, for the tenant in the first 12 months of that tenancy. So whilst there's no fixed term, it will be difficult but not impossible to get rid of a tenant during that protected period. There'll be limits to payments of rent up front. There will be a prohibition on giving tenancies to students which are more than 6 months in advance of them starting. This is to stop landlords, say, giving tenancies in a September which aren't going to start till the following August at the start of the year, and to stop people having to sign up to student tenancies prematurely. There'll be curtailments on bidding wars, which I'll come on to in a bit more detail. There will be prohibition of discrimination against tenants with children and on benefit. So essentially, you won't be able to have a blanket ban on taking tenants of that nature. And there will be new limits on rent increases. And then moving on to the remainder of the key changes, with a bit of luck. Here we are. There will be, this is obviously one of the ones that the papers like, new tenant rights concerning pets. There's going to be a centralised landlord database online. There's going to be a new ombudsman scheme for the private rental sector. The Decent Homes Standard and AWAB's law, which are interconnected, are going to be in application in the private rental sector to have similar effect to what they already have in the social housing remit. The local authorities are going to have much wider enforcement and powers of investigation, and there will also be wider use of rent repayment orders. So that is it in a nutshell, but let's look at it in a bit more detail. So what does the abolition of Section 21 and no fixed terms mean? Well, as I've said, Section 21 will no longer apply, and that won't be a way to get possession anymore. Tenancies are going to be on a rolling basis from the beginning. So that means that essentially, there won't be any fixed term. However, tenants will have what's going to be known as a protected period for the first 12 months of the tenancy. And the difficulty for landlords is it's a bit of a protection for tenants, but not necessarily a protection for landlords, because a protected period will still enable tenants to leave during that time. I think off the top of my head, by giving 2 months notice to their landlord. So you could have a position where a tenant has a change of circumstances and can end that tenancy quite soon into the agreement, and the landlord's back to having to find a replacement. I've said also that there may be greater burden on courts. This is because under Section 21, we have what's called an accelerated procedure, which is a method by which you can bring court proceedings without necessarily needing a hearing. With Section 8, which I'm going to come on to, you can't use an accelerated procedure, and that's going to fall away. So every case that requires court proceedings is going to have a hearing, obviously unless the tenant throws a towel in and leaves early. So how are you going to get possession? Well, you're not going to have Section 21, but you are still going to have Section 8, and the grounds that we rely on. So when you serve a Section 8 notice, you specify a particular ground or a selection of grounds, and they are going to be amended to make them wider. I have also put a note on the bottom of the slide that you can see to say that the requirement to provide deposit protection certificate and prescribed information, and I'll come on to gas safety as well, is going to become a condition of serving a valid Section 8 notice. At the moment, that's a bit of a loophole for landlords, whereby the court won't look into detail as to whether those requirements have been done when a Section 8 notice is served, but they will do that for Section 21. Under the new regime, we're expecting that you'll have to be compliant on all of those things to serve a valid Section 8 notice. Now, before I come on to look at some of the key grounds under the sorry, I just had a bit of feedback there. I'm just wondering if someone who's in the someone who's got administration rights, if they can just mute everyone. Sorry, I'm just having some feedback and it just threw me a little bit. Sorry about that.
I just did, Patrick.
Thank you very much. Before I move on, I just wanted to say that at the moment there are 17 possible grounds for possession under Section 8, and under the new regime there's going to be 36. So there are going to be more reasons that you can get possession, and they're going to be a bit more niche. I'm going to focus on, I think, 4 or 5 of the main ones. And obviously, I don't want to bore you to death with 36 different ones, some of which will probably never see the light of day. So looking at some of the main ones, I think these will be probably, maybe save for the student accommodation one, which might be niche to certain landlords. I think the other ones on the screen will cover most of the reasons that a landlord will want their property back. So we're going to have ground 1. Amended from the current ground 1. Essentially, you, i.e. the landlord or a close family member, want to live at the property. I've obviously mentioned the protected period, so you're not going to be able to serve a notice to be able to move into your own property during that protected period. However, you can serve a notice that expires at the end of that 12 months. You're going to have to give 4 months to say to your tenant that you want the property back to move into it. And obviously, to stop spurious claims under this ground, you're also going to be prevented from reletting the property once you've got possession back under this ground. So essentially, if you change your mind that you aren't going to move in, you're going to be stuck waiting for 12 months to tick round before you can legally let your property again. Separately to moving in yourself, you might want to sell your property. It might be worth more having vacant possession, which is quite a common reason we see landlords serve Section 21 notices at the moment. And similarly, you'll need to give 4 months notice, and that notice won't be able to expire before the end of the first 12 months. I've put a note, except where it's a CPO, that's a compulsory purchase order. Obviously, in some circumstances, you might be being forced to sell your property. And in that case, you might be able to serve a notice before the end of the first 12 months. Coming on to the possession of student accommodation, essentially, if you've got a HMO and all of your tenants are full-time students, you can give a notice to take possession back in order to re-let it to other students for the next academic year. As I've noted, that notice will have a narrow window of when it can expire. So you'll have to give 4 months notice, and it will need to expire between June and September. Now, Ground 6 is an interesting one because it does already exist, but it doesn't get used very much because I think most people just use Section 21 if they're planning to redevelop their property. Now, the new Ground 6, which is going to be amended slightly, will give landlords the ability to seek possession if they want to redevelop. Now, at the moment, there's not a very clear definition about what will be sufficient to count as redevelopment. But I think substantial refurbishments will be sufficient. It doesn't mean necessarily demolishing your building and putting something else in its place. And I can foresee that there might be some disagreements as to what exactly is good enough to meet this. But it might be, it might be something that some unscrupulous landlords might try and exploit. And then moving on to serious rent arrears, which I am imagining is going to be the main kind of tenant fault ground that's still going to be used. This is very similar to what we've already got under Ground 8, but the difference is going to be that rather than needing a minimum of 2 months rent owed to be able to rely on this mandatory ground, you're going to need 3 months rent owed to you. And you're also going to need to give 4 weeks notice before you commence your possession proceedings rather than the current 2. So it's less generous to landlords. And as my note at the bottom, the bullet point at the bottom says, if tenants owed universal credit by the state, then that can be offset against the rent arrears. Obviously, if they can prove that. So what happens if you, I don't know, serve a Section 21 notice, even though you know or are basically ignorant of the fact you need to do things under the new procedure when it comes in? Well, there is going to be an ability for local authorities to impose civil penalties of up to £40,000 for not following the correct procedure when it comes in. Obviously, a huge amount of money. It may not be the full fine or civil penalty that you get, but it could be significant. Also, in theory, you could get prosecuted under Protection from Eviction Act, which is something that applies. Obviously, now it's an act that goes back to 1977, and in theory, you can get unlimited fines on summary conviction, and it does still get used. So obviously that would probably be for more serious breaches, but in theory that could come into play. So moving on to the starting rent. So this is to do with the bidding wars point that I've mentioned. Now, landlords are going to be prevented from changing their mind about how much rent they want. So at the point that a property is marketed, either the landlord or the agent is going to have to propose a starting rent. And from that point onwards, they won't be able to invite or encourage any tenants to offer more. So obviously, particularly in places like London, we see properties get marketed for a figure. You might have 5 or 10 different parties interested in it. And before you know it, the landlord's getting 25% more than the advertised rate. Well, that's just simply not going to be possible. Even if the tenant offers them or prospective tenant offers them more money, they'll be required to say no. And as I've noted there, they'll be at risk of civil penalties, civil enforcement fines of £7,000, which could quickly wipe out any benefit to taking more money. Moving on to rent increases. At the moment, it's possible for landlords to essentially send an email to their tenant and say, I want to put your rent up in a month's time, for example. And if the tenant agrees that, then that's a legal amendment to the contract. You wouldn't do that in the fixed term, of course. That's once you're on the periodic basis. So say after the initial 12 months. That's not going to be possible anymore. You're going to have to do the formal route, which currently exists, which is known as a Section 13 route, serve a formal notice of rent increase. And you're only going to be able to do that after that protected period in the first 12 months has ended. And you'll only be able to do it once every 12 months from that point. I've noted that contractual rent increases won't be valid. So if, for example, you had a tenancy that said after 12 months the rent's going up 10% or up to a certain figure, that wouldn't be valid and would be essentially that clause would be null and void. Tenants will be able to apply to the tribunal when they receive this Section 13 notice if they object to the proposal, and the new rent won't apply until the determination is made, and as far as I'm aware, it won't have any retrospective effect. So essentially, tenants may as well challenge to the tribunal, because the tribunal is essentially generally speaking, a no-cost forum to determine disputes. And so if a tenant can delay things before their rent goes up, then why wouldn't they? And I think that might be a bit of a bugbear for a lot of landlords. I'm just looking for my next slide, which I think is the rent in advance one. So this is a change that's come in the amendment stage, I think, in the House of Commons in the Renters' Rights Bill, and that's one of the reasons why I had an asterisk on this particular one. And I think it was one of the student slides I've shown you. That's why I had an asterisk. So essentially, at the moment, we do see it, particularly again, some London properties. Often it's high-end properties where people might be giving 3 or even 6 months rent up front in advance at the beginning, rather than paying month by month. Now, this is going to be invalid from the Renters' Rights Bill. This new amendment's been incorporated. You'll only be able to get 1 month's rent in advance. And obviously getting rent in advance might be seen as a workaround where rental deposits have been curtailed over the last few years. In terms of rental deposits, the rules are, unless something changes before this becomes law, they're going to be as is. So where your rent per year is under 50,000, you're going to have a maximum of 5 months rent as a deposit, 6 weeks rent if you're lucky enough to have annual rent over 50,000. And I have speculated at the bottom about the potential for greater use of guarantors. Obviously, landlords are going to want to be satisfied that their tenant or someone on their behalf, if they need someone to step in, is going to pay the rent, and so guarantors, which obviously are used and have been used for many years, may become more prevalent. And I know that there are some professional guarantor schemes, essentially sort of rent insurance kind of schemes, and they may come to the fore. I touched upon the Decent Homes Standard and Awaab's law. So essentially, these are things which are either in place already or are in the process of being rolled out in the social housing sector and are going to become law for in the private rental sector too. Hopefully everyone here is a conscientious landlord with very good properties and essentially won't need to be too concerned about this. But in a nutshell, the Decent Home Standard requires you to be showing things like your property's warm. Obviously, if the tenant chooses not to turn the heating on, you're not going to be responsible for that. But essentially, it means appropriately insulated. So if it is heated properly, then it shouldn't all be disappearing out of the walls and the windows. It will need to be safe with reference to what's known as the Housing Health and Safety Rating System, and fit for purpose, which hopefully speaks for itself. Awab's law, some of you may be aware of Awab Ishak, who was a young child who unfortunately, very sadly, died in a property in Rochdale, which I think was owned by the local authority. It was health complications due to black mold, which they didn't address, even though there'd been complaints, and obvious risk to health. So Awab's law is essentially in memory of him, but it's going to place strict time limits on landlords to investigate issues that could be hazardous to health. The exact requirements on private landlords will be TBC, but essentially could well mean needing to investigate things like damp and mold within 24 hours of them being reported. Obviously, things that are frivolous, might not, but anything that's could potentially be very hazardous to health, I think they will need to be addressed. Otherwise, there could be serious repercussions for landlords. And as I've mentioned, there might be a sort of two-tier system where certain serious but not emergency things may be a little bit more time to resolve them. Moving on to pets, again, the media seem to love this at the moment. That's obviously Larry the cat, who I think has now left Downing Street, but was the chief mouser, I think he was called. So tenants will have the right to ask landlords to keep pets. Now, some people have sort of misinterpreted that as it being an outright human right or pet right to have a cat, have a dog, have a guinea pig. It's not, but landlords won't be able to unreasonably refuse their requests. And obviously, what's unreasonable will vary from case to case. Obviously, if you've got a 3-bedroom house being rented, having a large dog might be more reasonable than if you're in a studio flat. And there'll be lots of things in between. Landlords will obviously have to be able to justify their decisions. Landlords will be allowed to require either the tenant to get appropriate insurance to cover damage that might be caused by pets, or, as far as I'm aware, the landlord might be able to get that insurance himself, obviously, rather than leave it in the hands of the tenant, and may be able to seek reimbursement of that from the tenant as a condition. The other thing to note is, obviously, some landlords will themselves be a tenant, maybe under a long lease, and some long leases will have prohibitions on having animals, or there might be some kind of restrictive covenant in the title, or something which the landlord themselves would be in breach of if they gave permission, and that will be a good reason to say, sorry, you can't have a pet. So I've mentioned the private rental sector database. Now, because it's not yet been rolled out, we don't know exactly how it's going to work, but it will be mandatory for all landlords to join. And as far as we're aware, it will be the portal essentially to upload all of your documentation on to prove that you're compliant, to allow tenants to see what documentation there is, whether it's the tenancy agreement, the gas safety records, prescribed information, that kind of thing is what we foresee being on there. It will be mandatory, and if you don't register, then you are not going to be able to serve a Section 8 notice, save by the looks of things, unless you're seeking possession for antisocial behaviour. Now, things may change in the future. At the moment, we don't generally get instructed too much for seeking possession for antisocial behaviour, because usually there's an easier route to it, like rent-arrears or Section 21. But basically, you will need to be a member, a subscriber of the private rental sector database. So keep your eyes peeled for any information as it comes out about when you'll be able to sign up, because I'd imagine that there will be a period where you can sign up voluntarily, and it might be the kind of thing to do before it becomes compulsory, so you can get a feel for how it works and how to upload your documentation and things like that. Coming on to the private rental sector landlord ombudsman, I think that's going to be the full title for it, but they might come up with something better. It's going to be obviously somewhere where tenants are going to be able to make complaints, essentially. It will be mandatory for all landlords to join it, so you can't say, I'm doing my own thing. My managing agent has a complaint system that we're gonna use to determine things. You will have to be a member of the new ombudsman. And as I've mentioned on the slide, this will allow complaints about landlords' actions or failure to act and any behaviour that causes harm or inconvenience. So, you know, it could be all sorts of things. The washing machine's broken for 3 weeks and the landlord hasn't bothered to send anyone around to have a look at it. You know, that's probably the kind of thing we're looking at. And, you know, things that are more serious and things that are more trivial. The ombudsman is going to have the power, obviously, to decide whether there's any faults. You know, the landlord will have their own side of the story, and it might be that they decide nothing's been done wrong, but they will have the power to compel landlords to apologise, provide information, take remedial action, fix the washing machine in that example, or I guess pay compensation. Someone had previously asked me if landlords would be able to make complaints about their tenants through the ombudsman, so it'd be a two-way street. Unfortunately not. So if you've got a tenant who's annoying you, that's not going to be something you'll be able to utilise. So moving on to some of the new duties and prohibitions. Landlords are going to be required to provide a written statement of terms. We've referred this as a bundle of relevant information to the tenant at the start of the tenancy. This is the kind of information that we think is going to be on the database. There will be various documents which you'll need to upload. Your tenant will probably be able to see them even before they've signed the tenancy, and can make an informed decision. And then obviously as things change moving forward, you can upload new documents as you go. So some of the penalties here. Now, how widely they get used will be interesting to find out in practice when this all becomes law. But most of the things that you do wrong, you'll potentially be looking at a civil penalty of £7,000. And for the more serious ones, you're looking at a civil penalty of £40,000. And I have also mentioned, obviously, there are grounds in certain circumstances for criminal prosecution. So don't take any of this lightly. You obviously need to be aware that if things go wrong, you could be looking at a serious financial implication. If you purport to grant a fixed term tenancy, so you've got a new tenant and you say, I'm giving you a 12-month tenancy, and probably give them a tenancy document that says 12 months, that could be a £7,000 fine or civil penalty. If you serve a notice seeking possession in the incorrect format, so if, for example, when this all comes in, you serve your tenant with a Section 21 notice, that could be a £7,000 civil penalty. If you serve a Section 8 notice without a reasonable belief in that ground, then that could be a fine on prosecution, or up to a £40,000 civil penalty. So that could be that you make up that you're going to be moving back into the property when actually the next week you decide to let it to someone else for twice as much money. And you're not going to be able to just set up a company to work around this and say, well, you know, the company is going to have to pay the fine and I'll shut the company down. You know, unfortunately, they will be able to pierce the corporate veil and go behind that. So essentially, if you're involved with a corporate entity and you're in control of it, then you could have personal liability. Moving on to rent repayment orders. These are something which many of you will be familiar with. Hopefully no one's been on the wrong end of one. They are increasingly popular for tenants because it's a way of getting money, sometimes for inadvertent problems that the landlord has got with making sure their paperwork's in order. Some of the reasons why you can currently get a rent repayment order at the moment: unlawful eviction, which involves violence and or harassment; failure to comply with an improvement notice, that would obviously be a notice from the local authority. This is the one we see the most frequently at the moment with tenants applying for rent repayment orders. So control or management of an unlicensed house or HMO. So that's either letting a property without the proper HMO license in place, or more commonly, particularly in London and some other places doing it as well, where you need a selective license often as well as a HMO, or separately, depending on the nature of the property. I won't go into too much detail, but selective license often requires every rental property in the neighbourhood to have a license from the local authority that's allowed to be let on an assured tenancy basis. And if you don't have one, you can be liable for rent repayment order. And breaches of banning orders, that's essentially if you've been so bad that you're not allowed to be a landlord, and you are being a landlord, you might have to pay back the rent you've been receiving from your tenants. So what's going to change with rent repayment orders? Well, they're going to be expanded. So you might be on the wrong end of a rent repayment order if you knowingly or recklessly misuse a possession ground. So that's obviously going back to serving a Section 8 notice without a reasonable belief in it being true. Breach of a restriction on letting or marketing. Continued breach after imposition of a financial penalty, obviously carrying on to do something wrong when you've already got in trouble for it. Provision of false information to the database, I think that speaks for itself, or continued failure to register with the database after you've been fined for not being on it. So basically, if you don't act when you need to. So rent repayment orders, obviously, they can be applied for by local authorities, but generally it's tenants who apply for them. It's good money for tenants. Often they might be very happy in the property, but going back to the selective licensing point, there can be reasons why a landlord slipped up with their paperwork and a tenant sees it as a way to get some money back. And I guess, if they're allowed to do it, then they might say, why wouldn't they? Rent repayment orders at the moment can mean having to pay 12 months rent back to your tenant, and the application needs to be made within 12 months of the relevant breach. That's going to double on both counts. So the maximum amount of rent that can be paid back is going to be 24 months, 2 years, and the application will be possible to be made within two years as well. The amount that's paid, I should say, is at the discretion of the tribunal. So the more egregious breaches will be looking at the higher end. If it's a kind of mistake and the landlord can plead for mercy, then you're usually looking at the lower end, but it can still be a significant amount of money. So when and how is all of this happening? Well, we were actually thinking that the royal assent might even be, I was talking about this last year, that royal assent might have even happened by now. There have been some delays in Parliament. It's obviously a very contentious bill. And even as recently as the last week, there's been talk about the opposition, obviously the Conservatives, having some sort of secret meetings with landlord groups and various interested parties in the sector. Now, because this is a manifesto bill, there is a convention, I think it's called the Salisbury Convention, which basically means that it can't be put down entirely. They can't completely put a wrecking ball to it, but they obviously can slow the process down. And we think at the moment that the best guess is it might get royal assent late summer or in the autumn. But that obviously doesn't mean that it's going to commence from that point. And we are in the hands of the government as to when it will actually be rolled out. What we do know, two things. One, they've said that they think everything's going to be rolled out at the same time, whereas the previous bill, which was the Renters Reform Act under the previous government, or Renters Reform Bill, I should say, which didn't become law because it got timed out, that was going to be incremental. This is expected to be all at the same time, and the changes are going to apply to both new and pre-existing tenancies. So don't think if you've got a tenant at the moment, you can give them a 5-year tenancy and not have to worry about this for 5 years. It is going to apply to existing tenancies, so there's no workaround in that regard. But my guess, it's only a guess, but if it gets royal assent in the autumn, it might have a commencement date at some point in the first half of 2026. But it's very much up in the air. It is contentious. The government said they'll give as much notice as possible. That's hard to say what is as much as possible and what's reasonable. So we will have to wait and see. So what can you do? Well, if I can find my next slide, don't panic. It is a drastic change, but landlords will be able to live with it. Some people are worried, but I think the key things that you need to do are as follows. Be prepared. If you're on this webinar, then you are clearly taking it seriously and learning. Conduct a prompt review of your property portfolio. Identify any tenants that are at or close to the end of the fixed term. Decide if you want to seek possession using Section 21 while you still can. Obviously, if you're in the fortunate circumstance where you've got a tenant you're not particularly keen on and the AST is at an end, you can get rid of them now if you have your paperwork in order. Obviously, speak to an agent or a solicitor if you need to. Keep up to date with the developments. Things are changing week by week, month by month. Ensure you are compliant, or make sure that you've got your plans to do so. Speak to an agent. If you need to, speak to someone like me. Hopefully you won't need to speak to someone like me. Having a good agent's invaluable. And be prepared. I'm mindful of the time. I will just quickly run through my few slides on gas safety, but hopefully we'll then have some time for Q&A. So gas safety, there are basically 4 things to remember. You need to carry out checks on flues and apparatus every 12 months. Obviously, if any repairs are identified, you need to do that. And with regards to tenancies, you need to be serving a gas safety record prior to, i.e. at the start of the tenancy, and as you go, serving later. So every time there's a renewal, every time you have a check while your tenant's there, serving them the new gas safety record. Why is it important? Well, essentially, in the worst case scenario, your tenant dies and it's your fault. You could end up being convicted of manslaughter, but more realistically, it could invalidate your insurance. And the reason I wanted to mention it today is it's a very regular problem why we see that landlords can't obtain possession via Section 21. And under the new rules, you're going to need to be able to show compliance for Section 8. A big problem that we have at the moment is, as this case that is on your screen has answered, if a landlord had a gas safety certificate, a valid gas safety certificate at the start of the tenancy, but they forgot to give it to their tenant, that can be corrected later. But if they didn't have one in the first place, then that's probably something that they're never going to be able to correct, and therefore can't serve a Section 21 notice. And we do see that quite regularly. So get a gas safety check every 12 months, provide a copy of the certificate to each tenant at the start of the tenancy, provide the renewal certificates, keep good records, because you want to be able to show that you've given them all of this stuff so that when they say that they haven't, you can prove that they have. And also check the certificates, because your engineer might be in a rush. They might not have signed it properly. They might have missed dates off, put the wrong addresses on. And we do see some judges pick up on this kind of stuff and say that they're not going to give a possession order because the gas safety certificate has something wrong with it. I rushed through the end, but hopefully that all made sense. And I'll pass back to Harry. Hopefully we can do some questions for the next 10 minutes or so, perhaps.
Thank you very much, Patrick. That was great. Lots of information there. I hope everyone took lots of notes, because there was lots to cover there. We don't seem to have any questions in the Q&A as far as I can see. I'll give everyone a couple of minutes to pop one in. I'm just going to I've got 2 slides to cover us off. If you've got a question, you've got 2 minutes to pop it in the Q&A button, which is right at the top of the screen. But I will cover mine off whilst we're waiting.
Please do. I've got my pen here just in case I need one.
Okay. Okay, so I've just got some actionable steps just for landlords to get ready for Renters' Rights Bill. Patrick shares them as well. So my biggest thing would be to engage with your tenants now to ensure that they know what's happening and they understand what their obligations are going to be moving forward. It's also going to be really important that you get your property visits booked in. This is to make sure that you know who's living in the property, you know if they're looking after the property, that you know if there's damp and mold in the property. There's so many reasons to get your properties booked in and to make sure that they are regular and that you are recording them. The next thing would be to look at getting yourself a really good rent and legal policy. So there are many out there and they tend to cover things like rent arrears and eviction if you need it. After Renters' Rights Bill, you could be 12 months with arrears by the time you can get a tenant out because there are significant delays with our court system at the moment. So it's really important that you have protection over your rent, that if your tenant stops paying their rent, you will get paid it. So we have a policy at Andrews, it's £36 a month. You get paid your rent from the point that they stop paying it right up until the point of eviction, and they help you with the eviction as well. So there's lots of policies like that out there. And if you want to hear more about ours, I'm happy to talk to you about it. The next thing is to familiarise yourself with those Section 8 grounds that are coming, the ones that are there and the new ones, and the notice periods that go along with them. And lastly, it's to diarise your property reviews. So this is to check your market rent, your compliance to the property for service of Section 13. So you'll be able to serve these once every year. Just make sure you get these in the diary and that you conduct a proper review each year of what the rent should be for that property and serve a Section 13 if you need to. Again, agencies will be able to help you with that. We serve Section 13 to Andrews. We can help you out with that if that's something that you need. So just lastly, just to cover off, Andrews, we offer a free tenancy compliance health check. So this is where we will come out and we will look at your rental property with you. We'll go through all of the different aspects of legislation that as a landlord you are legally need to uphold, and we'll basically give you a risk rating for your rental property. We do this totally for free. We'll talk you through all of the different areas of risk for your property, the areas that you potentially could be at risk of fines, and then we will tell you how you can get it back on track, and we do this totally for free. So if you're interested in this, just let me know and we can book that in. So thank you very much, everyone.